Hey everyone, welcome back to the channel. In today's video, we've got something special for all you aspiring real estate professionals out there. We're diving into Chapter 3 of the UBC Real Estate Exam Prep with 60 unique practice questions that will test your knowledge and help you ace the exam. Whether you're studying for the first time or looking for a refresher, these questions will cover all the important topics you need to know. Grab your notes, get ready to test your knowledge, and let's jump right into it. This intro gives a welcoming tone and sets up the content, focusing on helping viewers prepare for the UBC Real Estate Exam. The term fee simple, A, indicates something less than absolute ownership of land. B, describes an unencumbered or clear title to land. C, was abolished by the Land Title Act. D, refers to an interest in land that does not amount to an estate. Correct answer. A indicates something less than absolute ownership of land. Explanation. Fee simple ownership provides the highest degree of ownership in land available under the law, but it is not absolute, because it is subject to certain limitations such as government powers, e.g. taxation, expropriation, escheat, and police power. Therefore, fee simple represents ownership with some restrictions rather than absolute ownership. UBC Real Estate Practice Questions, Chapter 3. Question 2. Which of the following statements about the fee simple estate is true? A. The term fee means that the rights exercisable by the holder of a fee simple estate have been acquired by a payment of money. Where the owner of a fee simple estate dies without a will, the property will escheat to the Crown. C. An owner of a fee simple estate has the right to sell, rent, or lease the estate. D. A fee simple estate is an estate that is held for a limited period of time. Correct answer, C. An owner of a fee simple estate has the right to sell, rent, or lease the estate. Explanation. A fee simple estate is the most complete form of ownership in land available under common law. The owner has the right to sell, rent, lease, or otherwise dispose of the estate. However, this ownership is still subject to certain limitations, such as government powers. The other options are incorrect because A. Fee does not refer to a payment but rather to the type of ownership. B. Property may escheat to the Crown only when the owner dies intestate and has no legal heirs, but this is not automatic. D. A fee simple estate is not limited in time and can theoretically last forever unless it is sold or transferred. Mary registers a document given to her by John in the Land Title Office. The document states that I, John, grant to Mary and her heirs, assigns, executors, and administrators a right-of-way for persons and vehicles along and upon the easterly 30 feet of the southerly 64 feet of Lot 1, Plan 910, in order to give access to Mary's property, Lot 2, Plan 910. The interest granted is A. A restrictive covenant, B. A lease, C. A license, D. An easement. Correct answer, D. An easement. An easement grants Mary a legal right to use a specific part of John's land, the easterly 30 feet of the southerly 64 feet of Lot 1, to access her property. This aligns with the definition of an easement, which allows a non-owner to use another's land for a particular purpose. Question 4. In British Columbia, there are 3 basic requirements for an easement. Which one of the following is not a requirement? A. There must be a dominant and servient tenement. B. The easement must accommodate the dominant tenement. C. The dominant and servient tenements must be owned by different parties. D. The easement must be capable of forming the subject matter of a grant. Correct answer C. The dominant and servient tenements must be owned by different parties. Explanation. While many easements involve different owners for the dominant, benefiting, and servient, burdened tenements, ownership by different parties is not strictly required. It is possible for one party to own both tenements initially and later transfer ownership of one, retaining the easement. The other 3 options are essential requirements for an easement in British Columbia. UBC Real Estate Practice Questions, Chapter 3. Question 5. Which of the following statements about easements is true? A. Only the landowner and not the land benefits from an easement. B. The granting of an easement by one landowner to another conveys ownership of the easement area to the dominant tenement owner. C. An implied easement may result if the intention of the property owners has not been sufficiently explicit. D. A tenant who occupies land under a 20-year lease can grant an easement to a neighboring property owner, and the easement, if registered in the land title office, will run with the land even after the lease expires. Correct answer C. An implied easement may result if the intention of the property owners has not been sufficiently explicit. Explanation. An implied easement can arise when the intentions of property owners are not explicitly stated but are evident from the circumstances, e.g., long-standing use of a pathway. Option A is incorrect because easements benefit the land, not just the landowner. Option B is incorrect as an easement does not convey ownership of the area to the dominant tenement owner. It only grants a right of use. Option D is incorrect because a tenant cannot grant an easement that exceeds the duration of their lease. Question 6. Which of the following is not normally included in the concept of real property? A. Natural features such as trees and streams. B. Movable objects such as furniture. C. Land. Man-made improvements such as buildings. Correct answer B. Movable objects such as furniture. Explanation. Real property typically includes land, natural features, e.g. trees, streams, and man-made improvements, e.g. buildings, attached to the land. Movable objects, such as furniture, are classified as personal property and are not considered part of real property. Question 7. Howard slipped on a patch of ice and broke his ankle when walking up Laura's driveway to deliver a package. As a result, Howard suffered loss of wages until he recovered. Which of the following statements is true? A. Howard is a trespasser. Therefore, Laura does not owe him a duty of care under the Occupiers Liability Act. B. If Laura had taken reasonable and responsible precautions, such as applying sand or salt regularly to prevent ice building up on the driveway, she will likely not be liable to Howard under the Occupiers Liability Act. C. If Laura is only a tenant under a month-to-month lease of the premises, she will not be liable to Howard. Laura will be liable to Howard for all his damages even if she was not negligent. Correct answer B. If Laura had taken reasonable and responsible precautions, such as applying sand or salt regularly to prevent ice building up on the driveway, she will likely not be liable to Howard under the Occupiers Liability Act. Explanation. Under the Occupiers Liability Act, property occupiers owe a duty of care to ensure their premises are reasonably safe for visitors. If Laura took reasonable precautions to prevent hazards, e.g. salting the driveway, she would likely not be held liable for Howard's injury. The other options misstate the law regarding trespassers, tenant liability, and strict liability. Question 8. Mary and John own a piece of real property as joint tenants. Which of the following is false? A. Mary could sever the joint tenancy without John's knowledge. B. Mary and John each have an undivided interest in the property. C. Mary and John each have a right of survivorship. D. Mary and John can have different interests in the property. Correct answer. Mary and John can have different interests in the property. Explanation. Joint tenancy requires that all owners have equal and undivided interests in the property. This means Mary and John must hold the same interest, e.g. 50-50 share, and meet the 4 unities of possession, interest, time, and title. Options A, B, and C correctly describe aspects of joint tenancy. Question 9. Fletcher owns Lot 1, a rock-strewn beachfront property to which he had added 1 ton of white sand imported from Aruba. Anna, owner of Lot 2, is Fletcher's neighbor. Lot 2 has a tennis court located near the beach. On windy days, the fine white sand on Fletcher's property is carried by the wind onto Anna's property, where it coats the clay surface of the tennis court, making it very slippery and hazardous for anyone playing there. Anna has discussed this problem with Fletcher on several occasions, but he has not done anything to prevent the problem from continuing. Anna has been unable to use her tennis court for several months as a result of the sand accumulating on the property. Which of the following statements is true? A. This is likely an example of the tort of trespass. B. This is likely an example of the tort of private nuisance. C. Anna has no basis in law on which to sue Fletcher because the problem is caused by natural forces. D. Fletcher may successfully defend against a lawsuit brought by Anna on the basis that the damage caused is unintentional. Correct answer, B. This is likely an example of the tort of private nuisance. Explanation. A private nuisance occurs when a person's use of their property interferes with another person's use or enjoyment of their property. In this case, Fletcher's sand is causing a persistent issue for Anna, which is a classic example of a nuisance. This is not trespass, option A, because the sand is not intentionally entering Anna's property, nor can Fletcher claim a defense of natural forces, option C, as he introduced the sand. Option D is incorrect because intent is not the issue in nuisance claims. It's about unreasonable interference. Question 10. Which of the following is an interest in land that can be valued? A, an easement or right-of-way, B, building scheme, C, leasehold, D, all of the above. Correct answer, D, all of the above. Explanation. All of the options listed represent interests in land that can be valued. Easement or right-of-way. This is a property interest that allows someone to use land for a specific purpose, e.g. access, and its value can be determined based on its impact on the land. Building scheme. This involves a set of restrictions or rules that apply to a development or neighborhood, and its value can be assessed if it affects property usage or marketability. Leasehold. A lease gives a tenant the right to use land or property for a specified period, and its value can be calculated based on rent, duration, and other factors. Question 11. Which one of the following actions would constitute a trespass? A. Mary arrives at Safeway just as the door is being locked for the day and convinces the clerk to allow her in for last-minute shopping. B. John is on a museum tour and wanders off through a door stating no admittance. C. Sue sells cosmetics door to door and walks onto Joan's property to reach her front door. D. All of the above would constitute trespass. Correct answer, B. John is on a museum tour and wanders off through a door stating no admittance. Explanation. Trespass occurs when someone enters another person's property without permission or legal right. Mary entering Safeway with permission from the clerk would not constitute trespass as she was allowed inside. B. John wandering into a restricted area of the museum through a no-admittance door constitutes trespass, as it is an unauthorized entry into a restricted area. C. Sue selling cosmetics door-to-door would generally not constitute trespass if she is simply approaching the door of Joan's property as part of her business. However, trespass could occur if she enters without permission. Therefore, B is the clearest example of trespass. Question 12. Bert and Ernie owned, as joint tenants, a revenue-producing property, which was leased to Oscar. Ernie died, leaving a will, which gave his interest in the property to Grover. Grover is now demanding 1/2 of the rent paid by Oscar. Bert refuses this request. Which of the following statements is true? A. Bert and Grover now own the revenue-producing property as joint tenants. B. Bert and Grover now own the revenue-producing property as tenants in common. C. No interest in the property could be transferred to Grover via Ernie's will because the entirety of Ernie's interest in the property passed to Bert when Ernie died. D. Ernie severed the joint tenancy by bequeathing his interest in the property to Grover. Therefore, Grover is entitled to a 1/2 interest in the property. Correct answer, C. No interest in the property could be transferred to Grover via Ernie's will because the entirety of Ernie's interest in the property passed to Bert when Ernie died. Explanation. In joint tenancy, the key feature is the right of survivorship, meaning when one joint tenant dies, their interest automatically passes to the surviving joint tenant, not to anyone named in a will. A is incorrect because the right of survivorship means Bert automatically inherits the property, so they do not become joint tenants with Grover. B is incorrect because Bert is the sole owner after Ernie's death due to the right of survivorship. C is correct because under joint tenancy, the deceased's interest passes to the surviving tenant automatically, meaning Ernie's will cannot transfer any interest to Grover. D is incorrect because Ernie's will does not sever the joint tenancy. The interest automatically passes to Bert due to the survivorship feature. Therefore, the correct answer is C. Question 13. Where two neighboring landowners contract to prevent one of them from putting their land to a certain use, they are said to have created A. a license, B. a limiting caveat, C. a restrictive covenant, D. an easement. Correct answer, C. a restrictive covenant. Explanation. A restrictive covenant is a legal agreement between two parties where one landowner agrees to limit or restrict the use of their land in a certain way, often to benefit the neighboring property. For example, one landowner might agree not to build a structure of a certain height or use their land for commercial purposes, preventing negative impact on the neighboring property. A. is incorrect because a license grants permission for a specific activity on someone else's land, but does not prevent use. B is incorrect because a limiting caveat is not a common legal term related to land use. A caveat typically acts as a notice of a claim or interest in land. D is incorrect because an easement is a right to use someone else's land for a specific purpose, like accessing a road or utility, not to restrict use. Thus, the correct answer is C, a restrictive covenant. Question 14. Akiko Yamada vacated the property she had just sold, taking all her household furniture. Assuming she has taken each of the following items, which items must Akiko replace? Assume that none of the following items have been dealt with specifically in the contract of purchase and sale. A small Persian throw rug from the front hall, which had been chosen especially to complement the colors in the marble on the floor. B, an antique stained glass window, which was hung on 2 large hooks in front of the living room window. C, wall-to-wall carpeting from the den, which had been attached to a tack strip that in turn was attached to the hardwood floor. D, Akiko must replace all of the above 3 items. Correct answer. Wall-to-wall carpeting from the den, which had been attached to a tack strip that in turn was attached to the hardwood floor. Explanation. In real estate transactions, what constitutes fixtures, items that are part of the property and must stay, and chattels, personal property that can be removed, is important. A, Persian throw rug. This is considered personal property, a chattel, because it is not attached to the property in any permanent way. Akiko can take it. Antique stained glass window. This is likely considered a chattel, as it can be removed without significant alteration to the property. C, wall-to-wall carpeting. This is a fixture because it is attached to the property through the tack strip. Fixtures are considered part of the property and must remain unless specifically excluded in the contract. Therefore, Akiko must replace the wall-to-wall carpeting since it is a fixture attached to the property. Question 15. A building scheme is a special example of a group of restrictive covenants attaching to 2 or more lots within a particular development plan. Which of the following statements concerning building schemes is false? A, the original purchasers must receive their fee simple title from the same seller. B, the seller must have intended the restrictions to bind each lot. C, buyers must negotiate any exemptions from the application of the building scheme individually prior to purchase. D, the restrictions must apply equally to all the individual lots and be consistent with a general scheme of development. Correct answer, C. Buyers must negotiate any exemptions from the application of the building scheme individually prior to purchase. Explanation. A building scheme involves a set of restrictive covenants that apply to multiple lots within a development. The goal is to maintain a consistent standard or character for the development. A, the original purchasers must receive their fee simple title from the same seller. This is true. A building scheme typically arises when a developer sells multiple lots with a common set of restrictions. B, the seller must have intended the restrictions to bind each lot. This is true. For the building scheme to be valid, the seller must have intended that the restrictions apply to all the lots in the scheme. C, buyers must negotiate any exemptions from the application of the building scheme individually prior to purchase. This is false. Buyers cannot negotiate exemptions from the building scheme individually. The restrictions are generally meant to apply uniformly to all lots, and exemptions would be part of the original agreement. D, the restrictions must apply equally to all the individual lots and be consistent with a general scheme of development. This is true. The restrictions in a building scheme are meant to apply equally to all lots and must support the overall development plan. Therefore, the false statement is C. UBC Real Estate Practice Questions, Chapter 3. Question 16. A life tenancy has been granted to Avon without liability for waste. For which of the following actions would Avon incur liability to the remainderman? A, failure to repair or maintain buildings and improvements on the land. B, erecting a chain-link fence across the center of the property. C, destruction and removal of all the buildings from the land out of spite to the remainderman. Avon would not be liable in any of the above situations. Correct answer, C, destruction and removal of all the buildings from the land out of spite to the remainderman. Explanation. A life tenancy grants the tenant, in this case, the right to use and occupy the property during their lifetime. The clause, without liability for waste, typically means that Avon is not liable for failing to maintain the property in a pristine condition or for making reasonable alterations. However, Avon would incur liability if their actions cause significant harm to the property or the value of the remainderman's future interest. Failure to repair or maintain buildings and improvements on the land. Typically, the life tenant is not liable for failing to repair or maintain the property unless such failure causes significant harm or waste to the property. B. Erecting a chain-link fence across the center of the property. This is generally considered a permissible alteration unless it causes significant damage or is unreasonable and would not typically incur liability. C. Destruction and removal of all the buildings from the land out of spite to the remainderman. This is waste and would likely result in liability to the remainderman. Even though Avon is granted without liability for waste for ordinary actions, the destruction of the property with the intent to harm the remainderman is a form of malicious waste, and Avon could be held liable. D. Avon would not be liable in any of the above situations. This is false because malicious waste, destruction out of spite, would lead to liability. Thus, C is the correct answer. Question 17. Which of the following options best describes a building scheme? A. It is a special example of a group of easements attaching to two or more lots in a development. B. It is a set of restrictions on a development used to maintain uniformity. C. It is used by developers to protect the buyer's rights to build according to their own tastes. D. It is a document filed with the disclosure statement on a conversion of an existing building to a condominium. Correct answer, B. It is a set of restrictions on a development used to maintain uniformity. Explanation. A building scheme is a set of restrictive covenants that apply to a development to maintain consistency and uniformity in the use of the land and buildings. It is commonly used in subdivisions or developments to ensure that all properties adhere to a certain aesthetic or set of rules, such as building materials, size, or style. The purpose is to protect the character and value of the development. A. It is a special example of a group of easements attaching to two or more lots in a development. This is incorrect because a building scheme involves restrictive covenants, not easements. B. It is a set of restrictions on a development used to maintain uniformity. This is correct. A building scheme uses restrictions to maintain uniformity in the development. C. It is used by developers to protect the buyer's rights to build according to their own tastes. This is incorrect because the purpose of a building scheme is to ensure uniformity, not to allow buyers to build according to their personal tastes. D. It is a document filed with the disclosure statement on a conversion of an existing building to a condominium. This is incorrect because a building scheme applies to new developments or subdivisions, not necessarily to condominium conversions. Thus, B is the best answer. Question 18. Which of the following statements about restrictive covenants is false? A. A restrictive covenant must be negative in nature. B. Both the benefited and burdened land must be precisely identified in the agreement or document creating the restrictive covenant. C. The burden of the restriction must have been intended by the parties to bind the land. D. The covenantor must retain the restricted property, as any subsequent buyer will not be a party to the original contract. Correct answer, D. The covenantor must retain the restricted property, as any subsequent buyer will not be a party to the original contract. Explanation. Restrictive covenants can bind future property owners, not just the original covenantor. The covenant can run with the land to subsequent buyers. A. True, restrictive covenants are typically negative. B. True, both the benefited and burdened land must be identified. True, the burden must be intended to bind the land. Thus, D is false. Question 19. Karen's neighbor, Jack, is a gas barbecue enthusiast who cooks 2 meals a day, 7 days a week, on his outdoor gas barbecue. As a result, the smoke and fumes are carried onto Karen's property. The barbecue smoke has discolored Karen's dining room curtains and killed her shrubs. Which of the following statements is true? A. Jack may be liable to Karen for private nuisance, and Karen may seek an injunction to prevent Jack from continuing the nuisance. If Karen chooses to sue Jack for negligence, she must prove that he has breached the duty of care owed to her by a reasonable person in Jack's situation. C. This scenario reveals a cause of action for interference with the airspace rights of a fee simple owner. D. Karen need not prove that she has suffered any form of damage to succeed in her lawsuit against Jack, because her cause of action is considered trespass and actionable per se, i.e., without proof of damage. Correct answer, A. Jack may be liable to Karen for private nuisance, and Karen may seek an injunction to prevent Jack from continuing the nuisance. Explanation. This situation describes a private nuisance because Jack's barbecue smoke is interfering with Karen's enjoyment of her property. Karen can sue for damages and request an injunction to stop the nuisance. B. Incorrect. In a private nuisance case, negligence isn't the central issue. It's the unreasonable interference with the use of land. C. Incorrect. Interference with airspace would be a separate issue not related to smoke causing nuisance. D. Incorrect. Karen must prove damage in a nuisance claim. It's not actionable per se like trespass. Question 20. Which of the following statements concerning restrictive covenants is false? A. The covenant must be worded in positive terms. B. The restriction must be intended by the parties to bind the land. C. The person who agrees to be bound is called the covenantor. D. A restrictive covenant will not be enforceable where the character of the neighborhood has changed so as to make enforcement useless. Correct answer, A. The covenant must be worded in positive terms. Explanation. A restrictive covenant is typically negative in nature, meaning it prohibits certain actions, e.g., no building over a certain height, no commercial use. A positive covenant would require something to be done, like maintaining property, which is not the usual case for restrictive covenants. B. True. The restriction must be intended to bind the land and affect future owners. C. True. The person who agrees to be bound by the covenant is the covenantor. D. True. A restrictive covenant may become unenforceable if the character of the neighborhood changes significantly, rendering enforcement meaningless. Question 21. A limitation or restriction placed upon the use of one person's land for the benefit of another is called A. Remuneration. B. A zoning bylaw. C. A restrictive covenant. D. An order absolute of foreclosure. Correct answer, C. A restrictive covenant. Explanation. A restrictive covenant is a limitation or restriction placed on the use of one property to benefit another, typically to maintain uniformity or protect the value of neighboring properties. A. Incorrect. Remuneration refers to payment or compensation, not a land use restriction. B. Incorrect. A zoning bylaw is a regulation that controls land use within a specific area, but it's not an agreement between landowners. Incorrect. An order absolute of foreclosure is a legal judgment that finalizes the foreclosure process, not a restriction on land use. UBC Real Estate Practice Questions, Chapter 3. Question 22. Which of the following statements about the law in British Columbia governing occupiers' liability is false? A. Under the statute, there can be more than one occupier of land at the same time. B. An occupier's liability does not extend to risks willingly assumed by a visitor at their own risks. C. The language of the Occupiers' Liability Act expressly preserves the common law distinction between the different types of visitors. D. The language of the Occupiers' Liability Act would probably allow for the imposition of a lesser standard of care to be owed to a trespasser than to a person with permission to be on the premises. Correct answer, C. The language of the Occupiers' Liability Act expressly preserves the common law distinction between the different types of visitors. Explanation. The Occupiers' Liability Act in British Columbia does not preserve the common law distinctions between different types of visitors, e.g., invitees, licensees, and trespassers. Instead, it imposes a general duty of care to all visitors, with the main distinction being based on the status of the visitor and the level of care owed. A. Correct. The Act allows for more than one occupier to be liable for the land at the same time. B. Correct. The Act does not hold occupiers liable for risks that visitors willingly assume. D. Correct. The Act allows for a lower standard of care owed to trespassers, depending on the situation. Question 23. Which one of the following actions would constitute trespass to land? A. The crossing of another person's property by mistake. The deliberate crossing of another person's property. C. The throwing of an item upon another person's property. D. All of the above. Correct answer, all of the above. Explanation. Trespass to land occurs when a person intentionally or unintentionally enters another person's property without permission. This can include A. Crossing another person's property by mistake. Though unintentional, it still qualifies as trespass if done without consent. B. Deliberately crossing another person's property without permission is a clear example of trespass. C. Throwing an item onto another person's property can also be considered trespass if it invades the land without the owner's consent. In all cases, the key is the unauthorized entry or interference with the property. Question 24. A visitor enters an apartment building to visit a tenant. As he enters the lobby, the skylight above collapses, injuring the visitor. If the visitor decides to sue the owner and/or building manager, what cause of action will the visitor likely use? A. Negligent misrepresentation. B. Occupier's liability. C. Breach of fiduciary duty. D. Nuisance. Correct answer. B. Occupier's liability. Explanation. Under occupier's liability, the property owner or manager has a legal duty to maintain the premises in a reasonably safe condition for visitors. If the visitor is injured due to a hazardous condition on the property, in this case, a collapsing skylight, the visitor would likely use occupier's liability as the cause of action to seek compensation for their injuries. This is because the owner or manager is responsible for ensuring that the premises are safe for visitors. UBC Real Estate Practice Questions, Chapter 3, Question 25. Mimi was house-sitting for her friends Tom and Lizzie while they were on a 3-month photo safari in Africa. The front porch was damaged in a freak storm that caused a tree to fall and smash the bottom 2 steps. Mimi didn't have the money to hire a carpenter to repair the stairs, so she attached a large sign to the bottom of the steps reading, "Danger, keep off." Dave, an out-of-work handyman who could not read English, was walking from house to house in the neighborhood looking for casual work. He entered Tom and Lizzie's property and, not understanding the sign, started up the steps to the front door. Dave landed on the damaged step, and the weight of his body was more than the step could stand. He broke his leg in 2 places and, having no insurance, has run up $3,750 in medical bills. Dave now intends to begin a lawsuit. Which of the following statements is false? A. Under the Occupier's Liability Act, both Mimi and the absent owners qualify as occupiers. B. Dave will be unsuccessful in his lawsuit because he willingly accepted the risk of injury when he walked up the broken steps. C. The duty of care owed by an occupier under the Occupier's Liability Act applies in relation to the condition of the premises, activities on the premises, or the conduct of third parties on the premises. D. A court will consider the reasonableness of the occupier's actions in order to establish liability in this case. Correct answer. B. Dave will be unsuccessful in his lawsuit because he willingly accepted the risk of injury when he walked up the broken steps. Explanation. Under the Occupier's Liability Act, an occupier owes a duty of care to all visitors, including people like Dave who are not familiar with the condition of the property. Even though Dave did not understand the warning sign, his willingness to enter the property does not automatically negate his right to sue for injuries if the occupier, Mimi or Tom and Lizzie, did not take reasonable steps to ensure the safety of the premises. The fact that Dave didn't understand the sign does not imply that he willingly accepted the risk of injury. The other statements about occupier liability are true as they address the duty of care owed, including considering the condition, activities, or conduct of third parties on the property. Question 26. Which of the following statements regarding joint tenancy is false? A. Where 2 legally married spouses own property in joint tenancy and one of them dies, the other becomes the owner of the whole interest. B. Where a joint tenant transfers their interest to a third party, the third party becomes a tenant in common with the original joint tenant. C. Where 2 legally married spouses own property as tenants in common and one of them dies, the other becomes the owner of the whole interest. D. A joint tenancy becomes a tenancy in common upon severance. Correct answer. C. Where 2 legally married spouses own property as tenants in common and one of them dies, the other becomes the owner of the whole interest. Explanation. This statement is false because, in a tenancy in common, when one of the tenants dies, their share of the property passes according to their will, or, if they have no will, to their heirs, rather than automatically transferring to the surviving tenant. This is in contrast to joint tenancy, where the right of survivorship applies, meaning the surviving joint tenant automatically becomes the owner of the entire property upon the death of the other. The other statements about joint tenancy are true. Question 27. The fact that a joint tenant's interest does not pass to a personal representative on death is referred to as A. An estate in inheritance, B. A tenancy in common, C. The right of survivorship, D. A life estate. Correct answer, C. The right of survivorship. Explanation. In a joint tenancy, the right of survivorship means that when one joint tenant dies, their interest in the property automatically passes to the surviving joint tenant, not to their heirs or personal representative. This is in contrast to a tenancy in common, where the deceased's share would pass according to their will or to their heirs. Question 28. Hurston, an employee of XYZ Preservatives Ltd., is in the habit of venting a cloud of highly toxic gas into the air at dusk every evening. Once it escapes, the cloud usually drifts over Ralph's apple orchard. Hurston's actions are strictly against company policy, but by venting the gas, Hurston saves time. Hurston is aware that the gas is highly toxic. Ralph has discovered that the emissions have destroyed his apple crop. Which one of the following statements is true? A. XYZ will not be liable for Hurston's acts because Hurston was acting contrary to XYZ's rules. B. Ralph may be successful in a claim against XYZ based on the principle of private nuisance. C. While Ralph will probably succeed in a claim against XYZ based on negligence, he will not have any remedy against Hurston. Ralph would probably have a successful claim against XYZ based on the provisions of the Occupier's Liability Act. The correct answer is B. Ralph may be successful in a claim against XYZ based on the principle of private nuisance. Explanation. Even though Hurston was acting contrary to company policy, XYZ Preservatives Ltd. could still be liable for the harm caused by Hurston's actions under the principle of private nuisance. The company is responsible for the actions of its employees when they are acting within the scope of their employment, even if those actions are unauthorized. In this case, the toxic gas vented by Hurston interfered with Ralph's use and enjoyment of his property, the orchard, which is a key element of a private nuisance claim. Question 29. Which of the following is not one of the three main classifications of interests in land that are less than estates? A. Easements, B. Profits a prendre, C. Restrictive covenants, D. Licenses. The correct answer is D. Licensplanation. Licenses are not considered a type of interest in land that is less than an estate. The three main classifications of interests in land that are less than estates are easements, profits a prendre, and restrictive covenants. A license, on the other hand, is a permission to enter or use land for a specific purpose, but it does not create an interest in land. Question 30. Which of the following statements regarding profits a prendre is true? A. A profit a prendre must accompany a dominant tenement. B. The right to fish on another's land is an example of a profit a prendre. C. A profit a prendre is always granted for a definite period of time. D. An owner who wishes to impose restrictions consistent with a general scheme of development would likely charge the land with a profit a prendre. The correct answer is B. The right to fish on another's land is an example of a profit a prendre. Explanation. A profit a prendre grants the right to enter someone else's land and take something from it, such as minerals, timber, or even fish, which is exactly what the right to fish on another's land represents. It does not necessarily accompany a dominant tenement. It can be for an indefinite period, and it is not typically used to impose restrictions for a development scheme. Question 31. Mary and John own a piece of real property as joint tenants. Which of the following is true? A. Mary cannot sell or mortgage her interest without John's consent. B. Mary and John must each have an undivided interest in the whole of the property. Because Mary and John are married, they were required by law to register their co-ownership. C. As joint tenants. All of the above. The correct answer is B. Mary and John must each have an undivided interest in the whole of the property. Explanation. In a joint tenancy, both co-owners have an undivided interest in the entire property, meaning each has an equal right to the whole property, not a portion of it. However, A is false because in joint tenancy, either co-owner can sell or mortgage their interest, but it can sever the joint tenancy. C is false because joint tenancy is not automatically required for married couples. They can choose between joint tenancy or tenancy in common. Question 32. The duty of care imposed by the Occupiers Liability Act does not apply to which of the following options? Risks willingly accepted by a person as their own risks. B, the condition of the premises. C, activities on the premises. D, the conduct of third parties on the premises. The correct answer is risks willingly accepted by a person as their own risks. Explanation. The Occupiers Liability Act imposes a duty of care regarding the condition of the premises, activities on the premises, the conduct of third parties on the premises. However, the Act excludes liability for risks that a visitor willingly accepts as their own, as long as the visitor's assumption of risk is reasonable in the circumstances. Question 33. Ethan visited a used car lot, owned and operated by Clara. The lot contains a variety of used cars, in addition to a marked-off area where Clara keeps a variety of car parts. There are large signs around the marked-off area, warning customers not to enter the area without the presence of an employee. Ethan, while walking around the lot, noticed a set of vintage car wheels in the marked-off area. Disregarding the signage, Ethan entered the area to get a closer look at the wheels. Unfortunately, Ethan stepped on a small engine part that was lying on the ground and slipped and broke his ankle. Which of the following statements is true? A. If Ethan had been trespassing on Clara's lot, Ethan would have been owed no duty of care whatsoever under the Occupiers Liability Act. B. If Ethan was an infant, he would likely be owed a higher duty of care than an adult because of an infant's relative inability to appreciate the danger presented by marked-off areas in a used car lot. C. Clara could not be held liable to Ethan if she was merely leasing the lot. Only the owner of the land can be sued under the Occupiers Liability Act. D. If Clara had an employee supervise the lot and Clara was away from the lot at the time of the injury, only the employee can be held liable under the Occupiers Liability Act. The correct answer is B. If Ethan was an infant, he would likely be owed a higher duty of care than an adult because of an infant's relative inability to appreciate the danger presented by marked-off areas in a used car lot. Explanation. Under the Occupiers Liability Act, occupiers owe a duty of care to ensure the premises are reasonably safe for all visitors, including trespassers. A higher standard of care is required for children because they may not fully understand or appreciate potential hazards. Other options are incorrect. A. Trespassers are still owed a limited duty of care under the Act. C. Both owners and occupiers can be liable under the Act depending on their level of control over the premises. D. Responsibility lies with the occupier, not just the employee. Question 34. Which of the following is not a characteristic of a fee simple estate? A. It is held subject to the Crown's land use regulations. B. It may be expropriated by the Crown. C. It is a leasehold interest. D. Its owner has it only for as long as they have heirs. The correct answer is C. It is a leasehold interest. Explanation. A fee simple estate represents the highest form of property ownership in common law, granting the owner full rights to the property, subject only to restrictions such as zoning laws or expropriation by the Crown. It is not a leasehold interest, which is a lesser estate where the holder has rights to the property for a defined period. Question 35. Anton holds a life estate per Autrevai based on Bentley's life. Charles has the remainder interest in fee simple. Anton's interest will terminate when A. Anton dies, B. Bentley dies, C. Charles dies, D. All three men die. The correct answer is B. Bentley dies. Explanation. A life estate per Autrevai is based on the lifetime of someone other than the life tenant, in this case Bentley. Anton's interest in the property will terminate upon Bentley's death, at which point the remainder interest passes to Charles in fee simple. Question 36. Which of the following statements about fee simple estate is true? A. Fee simple is a type of leasehold estate. If a fee simple owner dies without a will, the property will escheat to the Crown. C. The term fee simple indicates an estate that can be inherited without qualification. D. The fee simple estate was created by the Torrens system of registration. The correct answer is B. If a fee simple owner dies without a will, the property will escheat to the Crown. Explanation. If a fee simple owner dies intestate without a will and has no heirs, the property will revert to the Crown, escheat. Fee simple is not a leasehold estate, A, and predates the Torrens system, D. While it is inheritable, certain qualifications such as the existence of heirs apply, C. Question 37. Which of the following statements about fixtures and chattels is false? A. Where an item has been affixed for the enhancement of the use of the premises, that is evidence the item is a chattel. B. Where an item is affixed slightly to the premises, it will be considered, based on the first impression, to be a fixture. C. A chattel is the personal property of the owner. D. The test for fixtures and chattels examines the degree of affixation of an item and the purpose of affixation of the item. The correct answer is A. Where an item has been affixed for the enhancement of the use of the premises, that is evidence the item is a chattel. Explanation. If an item is affixed to the premises to enhance its use, it is more likely to be classified as a fixture, not a chattel. Fixtures are considered part of the property, while chattels remain personal property. The other statements are correct regarding the rules for distinguishing fixtures and chattels. UBC Real Estate Practice Questions, Chapter 3. Question 38. In British Columbia, there are 3 basic requirements for an easement. Which one of the following is a requirement? A. The easement must be negative in nature. B. The easement must accommodate the servient tenement. C. The dominant and servient tenements must be owned by different parties. D. The easement must be capable of forming the subject matter of a grant. The correct answer is D. The easement must be capable of forming the subject matter of a grant. Explanation. For an easement to exist in British Columbia, it must meet 3 basic requirements. 1. There must be a dominant and a servient tenement. This is not the same as the dominant and servient tenements being owned by different parties. 2. The easement must accommodate the dominant tenement, not the servient tenement. 3. The easement must be capable of forming the subject matter of a grant. Question 39. Which one of the following is not a remedy available for a private nuisance? A. Abatement. B. Damages. C. Specific performance. D. Injunction. The correct answer is C. Specific performance. Explanation. Specific performance is a remedy typically used in contract law, requiring a party to fulfill their contractual obligations. It is not applicable in private nuisance cases. Remedies for private nuisance include abatement, self-help measures to stop the nuisance. Damages, monetary compensation for losses caused by the nuisance. Injunction, a court order to prevent the continuation of the nuisance. Question 40. The owner of an interest in real property that is located in British Columbia always has A. A fee simple interest. B. The right to use their property in any way they choose. C. At least a 99-year lease from the Crown. D. Common law rights as modified by legislation. The correct answer is D. Common law rights as modified by legislation. Explanation. In British Columbia, property ownership is governed by common law, but these rights are subject to modification and regulation through statutes like the Land Title Act, Property Law Act, and municipal zoning laws. Owners do not have unrestricted rights to use their property and may not necessarily hold fee simple or leasehold interests. Question 41. Mr. and Mrs. Tom Jones and Ashraf Menzies have a signed contract of purchase and sale for a triplex owned by Alan Sinclair. Mr. and Mrs. Jones have agreed to pay $100,000 each, and Ashraf has agreed to pay the balance of $50,000. They would like their ownership registered as a joint tenancy. Which one of the following statements is true? A. Tom, Mrs. Jones, and Ashraf cannot register their ownership as a joint tenancy because they did not each contribute the same amount of cash. B. If their interest is registered as a joint tenancy, Tom, Mrs. Jones, and Ashraf will each own an undivided interest in the triplex. C. Tom and Mrs. Jones would be allowed to register their interests as a joint tenancy because they are husband and wife, but Ashraf would have to be a tenant in common with them. D. Tom, Mrs. Jones, and Ashraf cannot meet the 4 common law principles required to create a joint tenancy. The correct answer is B. If their interest is registered as a joint tenancy, Tom, Mrs. Jones, and Ashraf will each own an undivided interest in the triplex. Explanation. A joint tenancy requires the 4 unities: possession, interest, time, and title. If the parties agree to register as joint tenants, they will each hold an undivided interest in the whole property, regardless of their unequal financial contributions. Question 42. Which one of the following is not essential in order to constitute a restrictive covenant in law? A. It must be positive in nature. B. It must be negative in nature. C. At least two parcels of property must be involved. D. The burden of the restriction must have been intended by the parties to bind the land. The correct answer is A. It must be positive in nature. Explanation. A restrictive covenant is a legal agreement that restricts the use of land in a certain way, usually negative, meaning it prohibits specific actions. It is not required to be positive in nature, as it typically restricts or prevents certain uses of land rather than requiring an affirmative action. Question 43. Eugene and Lenore visited Green Maple Tree Farms. The property is owned and operated by Rodney. Trees kept for sale are placed in holes in the ground with their roots encased in burlap. The holes are not filled in when a tree is removed, but are located in a grid pattern which is apparent to any viewer. Signs are located at the beginning and end of every row of trees, warning customers to watch for and avoid open holes. Eugene and Lenore walked among the rows of trees while selecting a tree for their purchase. Eugene and Lenore noticed an open hole, approximately 3 feet in diameter. Lenore walked around the hole, and Eugene attempted to step across the hole. Eugene fell into the hole and fractured his leg. Shortly after this event, Lenore tripped over a green garden hose lying unseen in the grass between the rows of trees, which was left by Rodney earlier in the day. Lenore broke her arm in her fall. Which of the following statements is true? A. Rodney is liable to both Eugene and Lenore for their injuries suffered as a result of his breach of the duty of care owed to them under the Occupiers' Liability Act. B. Rodney can successfully defend against a lawsuit by both Eugene and Lenore using the defense contained in the Occupiers' Liability Act that an occupier has no duty of care to a person in respect of risks willingly accepted by that person as their own risks. Eugene will probably not recover any damages in a lawsuit against Rodney because he breached his duty to take reasonable care for his own safety. He was the author of his own harm. D. Rodney will not be liable for either Eugene or Lenore's injuries if he was not at Green Maple Tree Farms at the time that the injuries occurred. The correct answer is A. Rodney is liable to both Eugene and Lenore for their injuries suffered as a result of his breach of the duty of care owed to them under the Occupiers' Liability Act. Explanation. Under the Occupiers' Liability Act, Rodney, as the occupier of the land, owes a duty of care to visitors to ensure that the premises are reasonably safe. Although Eugene and Lenore were warned about the holes, Rodney could still be liable for the hole Eugene fell into if it was deemed not to have been properly managed. Similarly, Lenore tripped on a garden hose that Rodney left unattended, which could also be seen as a breach of his duty of care. Question 44. Ownership of land in British Columbia includes not only the surface of the land, but also A. the column of airspace above it, insofar as the owner can see. B. the gold and silver below the land to a depth of 10 feet. C. Objects affixed to the land for the purpose of improving the land. D. Petroleum down to the center of the earth. The correct answer is C. Objects affixed to the land for the purpose of improving the land. Explanation. Ownership of land in British Columbia typically includes not only the surface but also the rights to things that are affixed to the land, such as buildings, structures, and other improvements. This principle is related to the concept of fixtures. Other rights, like those to airspace, minerals, or petroleum, may be subject to specific regulations or crown ownership, which limits the scope of private land ownership. Question 45. Robert is dying of a terminal illness. He therefore arranges for his wife Elaine to have a life estate with respect to his ancestral home with the fee simple to go to his daughter Whitney once Elaine dies. Whitney's interest is that of a reversioner, B. remainderman, C. rectification, D. none of the above. The correct answer is B. remainderman. Explanation. In this scenario, Whitney holds the remainder interest in the property, meaning she will inherit the fee simple interest in the ancestral home once Elaine's life estate ends. The person who holds the future interest after a life estate is called the remainderman. Question 46. Hurston, the head of production at XYZ Preservatives Limited, has been ordered by the company's president in Toronto to vent some gases that have been stored in a pressure chamber at the Vancouver plant. Although the president knows that the gas is highly toxic, Hurston has been assured by the president that the gas is totally harmless and will quickly dissipate when released. Unfortunately, having escaped from the pressure chamber, the gas drifts in a dense cloud over Ralph's neighboring apple orchard and destroys the apple crop. Which one of the following is true? A. Ralph will be successful in a claim against XYZ's president under the doctrine of trespass. B. Ralph will probably succeed in a claim against XYZ based on negligence. C. Ralph will be successful in his claim against XYZ based on XYZ breaching its fiduciary duty towards Ralph. D. Ralph would probably have a successful claim against XYZ based on the provisions of the Occupier's Liability Act. The correct answer is B. Ralph will probably succeed in a claim against XYZ based on negligence. Explanation. Ralph may succeed in a claim based on negligence because XYZ Preservatives Limited and possibly Hurston as an employee had a duty of care to avoid causing harm to others, including Ralph. The company's president's assurance that the gas was harmless is likely negligent, especially given that the gas turned out to be highly toxic. This breach of duty caused damage to Ralph's apple crop, leading to a potential successful negligence claim. Question 47. A life tenancy has been granted to Avon without impeachment for waste. For which of the following actions would Avon be liable? A. Putting new shingles on the garage roof. B. Allowing the tool shed to deteriorate and collapse. C. Cutting down some trees on the property. D. Avon would not be liable in any of the above situations. The correct answer is B. Allowing the tool shed to deteriorate and collapse. Explanation. The phrase without impeachment for waste means that Avon is not liable for committing voluntary waste, which refers to substantial damage or destruction to the property. However, Avon is still responsible for permissive waste, which occurs when they fail to maintain the property or allow it to deteriorate through neglect. In this case, allowing the tool shed to deteriorate and collapse would be considered permissive waste for which Avon could be held liable. On the other hand, actions like putting new shingles on the garage roof, which typically enhances or maintains the property, or cutting down trees, depending on the context, are not generally considered waste. Question 48. The greatest bundle of rights and responsibilities that an individual can hold with respect to land is A. A fee simple interest. B. A 99-year lease. C. An easement. D. An estate per autre vie. The correct answer is A. A fee simple interest. Explanation. A fee simple interest is the greatest and most complete form of ownership that an individual can have in land. It grants the holder full rights to the property, including the right to use, lease, sell, or transfer it, and it can be inherited. This interest is subject to land use regulations but is not limited by time or conditions, unlike other types of interests. The other options are more limited. A 99-year lease grants a long-term but not indefinite interest in land. An easement is a right to use another person's land for a specific purpose, not full ownership. An estate per autre vie is an interest that lasts for the life of another person, not the holder's own life. Question 49. There were 3 categories of waste at common law with respect to real property. Which one of the following is not one of those categories? A. Equitable. B. Voluntary. C. Permissive. D. Ameliorating. The correct answer is A. Equitable. Explanation. At common law, the 3 categories of waste with respect to real property are voluntary waste. This occurs when the tenant intentionally damages or alters the property in a way that diminishes its value, e.g., cutting down trees. Permissive waste. This happens when the tenant fails to take proper care of the property, allowing it to deteriorate or fall into disrepair through neglect. Ameliorating waste. This is when the tenant makes improvements or changes to the property that increase its value, which can still be considered waste if not authorized by the property owner. Equitable waste is not one of the traditional categories of waste. However, it is a term used in the context of equitable remedies, particularly regarding life tenants and trustees, where the court may intervene to prevent waste, even if the type of waste does not fall into the traditional categories. UBC Real Estate Practice Questions, Chapter 3. Question 50. Which of the following situations are consistent with the existence of a joint tenancy under current British Columbia law? A. Herman was a co-owner of Blue Acre. When Herman died, the surviving co-owners of Blue Acre automatically became its only co-owners. B. Joan and Anna are co-owners of Greenacre. The document transferring the property to them does not expressly state how they hold the property or what interest each owns. C. Paul, a co-owner of Blackacre, together with Peggy, transferred his interest in the property to his son and registered the transfer in the Land Title Office. Paul's son is now a co-owner together with Peggy. D. Bert and Ernest are co-owners of Whiteacre. The front half of the property is Bert's and the back half is owned by Ernest. The correct answer is A. Herman was a co-owner of Blue Acre. When Herman died, the surviving co-owners of Blue Acre automatically became its only co-owners. Explanation. This situation is consistent with a joint tenancy. In joint tenancy, the most notable feature is the right of survivorship, meaning that upon the death of one co-owner, their interest automatically passes to the surviving joint tenants. This is exactly what is described in option A. Let's break down the other options. B. Joan and Anna are co-owners of Greenacre. The document transferring the property to them does not expressly state how they hold the property or what interest each owns. This is not necessarily consistent with joint tenancy because if the deed does not specify the type of ownership, it might default to tenancy in common, depending on jurisdiction or intent. C. Paul, a co-owner of Blackacre, together with Peggy, transferred his interest in the property to his son and registered the transfer in the Land Title Office. Paul's son is now a co-owner together with Peggy. This would break the joint tenancy because a joint tenant cannot transfer their interest without severing the joint tenancy and creating a tenancy in common. So, Paul's son would be a co-owner, but the ownership structure would change to a tenancy in common, not a joint tenancy. D. Bert and Ernest are co-owners of Whiteacre. The front half of the property is Bert's and the back half is owned by Ernest. This description does not reflect a joint tenancy. Rather, it suggests a tenancy in common with distinct shares or parcels of land. Joint tenants must have an undivided interest in the whole property. Thus, A is the only scenario that correctly describes a joint tenancy under British Columbia law. Question 51. Ownership of land includes not only the surface of the land, but also which of the following options? A. The column of airspace above it, insofar as the owner can make effective use of it. B. The branches of any of the neighbor's trees that hang over the owner's property. C. Anything that comes over the boundary line. D. All of the above are included in ownership of land. The correct answer is A. The column of airspace above it, insofar as the owner can make effective use of it. Explanation. Ownership of land includes not only the surface, but also certain rights above and below the land. This can include the airspace above the property, but the owner's rights are generally limited to the reasonable use of that airspace, e.g., constructing buildings or structures. The extent of this airspace is subject to local laws and regulations, including air traffic regulations. Now let's review the other options. B. The branches of any of the neighbor's trees that hang over the owner's property. Ownership of land does not automatically include the right to control or remove branches from a neighbor's tree. The property owner has the right to remove any branches that encroach onto their land, but this is a specific legal right, not a broad part of land ownership. C. Anything that comes over the boundary line. This is not automatically included in ownership. While landowners have certain rights over encroachments or trespasses across property lines, ownership does not automatically extend to any items that cross the boundary line from neighboring properties. D. All of the above are included in ownership of land. Since B and C are not included in ownership by default, this statement is incorrect. Question 52. There is a large Olympic-sized pool in the backyard of the home Margaret owns in Coquitlam. Each week in the summer, a worker from a pool maintenance company comes in and cleans the pool. Usually when he is cleaning the pool, the backwash runs over and chlorinated water leaks down on the garden of the neighbor below, killing the flowers. Both Margaret and the worker from the pool company are aware of what is happening. This would be considered which of the following? A. Breach of the duty of care under the BC Occupiers Liability Act. B. A private nuisance. A patent defect. D. Occupiers liability. The correct answer is B. A private nuisance. Explanation. A private nuisance occurs when someone's use of their property causes harm or interference with a neighbor's use or enjoyment of their own property. In this case, Margaret's pool backwash, which contains chlorinated water, is flowing onto her neighbor's property and causing harm to the flowers in the garden. This constitutes an interference with the neighbor's use and enjoyment of their property, which is a characteristic of a private nuisance. Here's why the other options are not correct. A breach of the duty of care under the BC Occupiers Liability Act. The Occupiers Liability Act typically applies to the safety of individuals on the property, rather than issues of property damage or interference like in this case. While Margaret may have a duty to ensure people on her property are safe, this situation is more about property damage, making nuisance a more appropriate category. C. A patent defect. A patent defect refers to a visible or obvious defect in a property, typically something that might make it dangerous or unsuitable. The backwash issue described here is a situation of harm caused by the pool's operation, not a structural defect. D. Occupier's liability. Occupier's liability focuses on the duty of the property owner to ensure the safety of visitors or individuals on the property. This case involves property damage to a neighbor's garden, so it's more related to nuisance than occupier's liability. Thus, private nuisance is the most accurate description of the situation. Question 54. Geeta was out walking and saw a for sale sign on the lawn of a house called Green Acres. She decided to ask the owners about the price of the property. Unknown to Geeta, the owners of Green Acres were away on a long vacation in Jamaica. As Geeta was walking across the lawn of Green Acres, a long branch from an old tree that grew in a neighboring yard fell down and hit her. As a result, Geeta broke her leg and could not return to work for 2 months. Which of the following statements is true? A. The owners of Green Acres will be held liable to Geeta for her lost wages only if Geeta can prove they knew of the hazard presented by the old tree. B. The owners of Green Acres will not be held liable to Geeta because they were not home at the time of the accident. C. Only the owners of the tree are liable to Geeta for her lost wages. D. The owners of Green Acres may be liable to Geeta even though they were not home at the time of the accident. The correct answer is D. The owners of Green Acres may be liable to Geeta even though they were not home at the time of the accident. Under the Occupiers Liability Act, property owners have a duty of care to ensure that their property is safe for visitors, even if they are not physically present. In this case, if the owners knew or should have known about the dangerous tree, they could still be held liable. Question 53. Which of the following statements about fixtures and chattels is false? A. When a chattel becomes attached, even slightly, to real property, it is presumed to be considered a fixture unless circumstances show that the item was intended to remain a chattel. B. A seller of real property has the right to detach and remove any fixture after entering the contract of purchase and sale if they so desire. C. When an owner of a house attaches a mirror to the wall, to better use the mirror, they will usually be entitled to remove the mirror when the house is sold and the seller moves out. D. If an object cannot be removed without damaging the real property, this is an indication that the object is a fixture. The correct answer is B. Because once a purchase and sale contract is signed, the seller cannot remove fixtures unless the contract allows it. Fixtures are part of the property unless specifically excluded. The other options are true. A. Attachments are usually considered fixtures unless proven otherwise. C. Mirrors can typically be removed if they are not permanently fixed. If removal damages the property, the item is likely a fixture. Question 55. Which of the following is a basic requirement for an easement in British Columbia? A. The easement must be negative in nature. B. The easement must be capable of forming the subject matter of a grant. C. The dominant and servient tenements must be owned by different parties. D. The easement must accommodate the servient tenement. The correct answer is B. The easement must be capable of forming the subject matter of a grant. In British Columbia, for an easement to be valid, it must meet certain criteria. 1. Capable of forming the subject matter of a grant. The easement must be clearly definable and its purpose must be legal and specific. It must be capable of being granted in a way that can be recorded and enforced. 2. dominant and servient tenements must be owned by different parties. For a true easement to exist, there must be two separate properties, one benefiting from the easement, dominant tenement, and the other burdened by it, servient tenement. The easement must accommodate the servient tenement. The easement must benefit the dominant tenement in a way that is reasonable and connected to the use of the land. It should not be for purely personal or non-property related benefits. While an easement can be negative in nature, e.g., preventing a certain activity, it is not a basic requirement. Therefore, the key requirement is that the easement must be capable of forming the subject matter of a grant. Question 56. Which of the following options best completes this sentence? A private nuisance involves some use of a person's own property that A. endangers the safety or comfort of the public or some major section of the public. B. amounts to a trespass. C. interferes with the use and enjoyment of or causes damage to the property of another. D. causes physical damage to the person's own property. The correct answer is C. interferes with the use and enjoyment of or causes damage to the property of another. Explanation. A private nuisance occurs when someone's use of their property significantly interferes with their neighbor's ability to enjoy or use their own property. This could involve noise, pollution, or other disturbances that affect the neighbor's comfort or cause damage to their property. It doesn't necessarily involve physical trespass, but rather an ongoing interference. Question 57. Cornelius gave a life tenancy to Reuel, which did not expressly state anything about Reuel's liability for waste. Reuel will not be liable to the remainderman for A. permissive waste, B. voluntary waste, C. ameliorating waste, D. equitable waste. The correct answer is A. permissive waste. Explanation. In the absence of an express clause regarding waste, a life tenant is generally not liable for permissive waste, damage due to neglect or failure to repair, as this is considered a normal consequence of occupancy. However, the life tenant may be liable for voluntary waste, intentional damage or destruction of property, ameliorating waste, improvements that increase value but are inconsistent with the property's current use, or equitable waste, damaging property in a way that impacts its long-term value, as considered in equity. Question 58. Which of the following is true regarding the transfer of a life estate? A. The life tenant can transfer their interest in the life estate, but the transfer will end when the life tenant dies. B. A life estate can be transferred only to a family member of the life tenant. C. The life tenant's interest can never be transferred during their lifetime. D. A life estate automatically becomes a fee simple estate upon transfer to a new owner. The correct answer is A. The life tenant can transfer their interest in the life estate, but the transfer will end when the life tenant dies. Explanation. A life tenant has the right to transfer their interest in the life estate, but the new owner will only have the right to use the property for the duration of the life tenant's life. Once the life tenant dies, the life estate terminates, and the property passes to the remainderman or reverts to the original grantor, depending on the terms of the estate. The transfer does not extend the life estate beyond the life tenant's life. Question 59. Which of the following is true regarding the transfer of a life estate? A. The transferee of a life estate has full ownership rights to the property, even after the life tenant dies. B. A life estate can be transferred to another person, but the transfer ends when the life tenant dies. C. A life estate holder can lease or sell the property, and their rights will extend beyond their lifetime. D. The life tenant must retain ownership of the property until they transfer it to the remainderman. Correct answer, B. A life estate can be transferred to another person, but the transfer ends when the life tenant dies. Explanation. A life tenant can transfer their life estate interest to someone else, but this transfer is limited to the duration of the life tenant's life. Once the life tenant dies, the life estate terminates, and the property passes to the remainderman, the person who has the remainder interest. The new transferee only holds the property for as long as the original life tenant is alive. Question 60. Which of the following is an example of voluntary waste committed by a life tenant? A. A life tenant failing to repair a leaking roof, which causes damage to the property. B. A life tenant cutting down trees on the property without any purpose for the land. C. A life tenant allowing a building on the property to deteriorate from neglect. D. A life tenant using the property in a way that increases its value. Correct answer, B. A life tenant cutting down trees on the property without any purpose for the land. Explanation. Voluntary waste refers to deliberate or intentional acts that reduce the value of the property, such as cutting down trees or removing valuable fixtures without purpose. This type of waste is intentional and reduces the property's value, which is considered improper use of the property during the life tenant's term. Thanks for watching today's video. I hope these 60 unique practice questions helped you feel more prepared for your UBC real estate exam. If you found this video useful, make sure to like, comment, and subscribe for more real estate tips and practice questions. Good luck with your studies, and I'll see you in the next video. Keep studying, stay focused, and make those dreams of becoming a realtor a reality.